So we've talked a lot about the court as an institution and about sort of the nuts and bolts of the decision-making process. I'd like to close with a few questions about your individual experiences on the court, or your experiences as justices. Justice Lemons, maybe I can start with you. How would you describe your judicial philosophy? Or maybe another way of phrasing it is, how do you think your colleagues would describe it?
Well, hopefully they're pretty close to one another. Well, I suspect we will. I think that a judge should be restrained in how they resolve the matters that have been presented to them. And that requires you to be, in some respects, a minimalist. You don't decide questions that are not necessary. You decide only questions that are, and you do it as narrowly as possible. And you do it because you respect other branches of government. You do it because there are some issues that are better left to other branches of government. There are some issues that ought to be decided by the branch that's being elected by the people directly. So I think my colleagues would say that I am somewhat of a minimalist in the true common law tradition of incremental change in the law, modest writing, narrow writing. At least that's what I aspire to do.
Do you find that frustrating, the minimalist approach? You mentioned earlier as part of our discussion that there are some issues that simply aren't presented to the court, but that the court might welcome at some point hearing about, and that there are some issues that simply aren't for the court to decide, they're for the legislature, even though you personally might not have decided them the same way. So does that approach, do you ever find that sort of personally frustrating, that there are issues simply that aren't there for you to decide?
Well, there are some cases that I wish there were issues properly presented to us that we could reach. But you see, we're full circle now. Because if we're frustrated enough to go out and reach them, then we are legislating. We're beyond the boundaries of what has been properly presented to us. And as a result, we simply wait patiently and hope that in the future somebody will raise the question that many of us have been wanting to answer.
Justice MIMS, do you share the judicial philosophy of minimalism? I think perhaps you do, based on your earlier comments.
I would not emphasize the word minimalism as much as I would emphasize the word incrementalism. I respect and agree with what Justice Lemons has said, but I think that the incremental approach is a hallmark of a thoughtful court, and so we have to, as I mentioned earlier, we exist within the bounds of law and tradition. And when it comes to interpreting the law, the statutory interpretation, we have to tread carefully, recognizing that we are not to legislate, that our job is simply to apply the various rubrics to determine what did the General Assembly intend to say, and then we apply it to that particular case. When it comes to the law development on the common law side that Justice Lemons was talking about, it should develop incrementally. We are painting on a field where 800 years of judges have come before us. And I don't pretend for an instant that I have the wisdom to just simply go off in an entirely different direction.
Was this a new or difficult experience for you to get used to, given your previous career experience in both the legislative and executive branches?
Sure, absolutely. And I'm not sure that I have reached a level of competence yet, but I really appreciate the fact that my colleagues have such experience and often such patience with having a former legislator on the bench.
Can you say a little bit more about that?
Well, I think that when you look back through the Virginia Supreme Court throughout the 20th century and into the 21st, there have often been former legislators on the bench or former executive officials on the bench. And I believe that, that we bring a different perspective and an important perspective. But we should also, as a Commonwealth, be quite thankful that on a court of 7, there's not 7 former legislators. Otherwise, you'd have an entirely different judiciary. Most of the individuals who come to the Virginia Supreme Court have been circuit judges in Virginia. 4 out of the 7 of us were. And that is the bedrock of experience. Those of us who came through a different route are able to contribute as well in an important way. But all of our cases, with very few exceptions, have come from the circuit courts. And so I particularly have appreciated the experience and the knowledge that those colleagues have brought to me.
So let's talk a bit about previous career experience. So Justice Powell, you've had a variety of experiences before you took the bench. In-house counsel, executive branch, private practice, service on each of the lower courts. How do you think that's influenced your work here on the court?
Certainly the prior trial court experience has been very helpful if I'm looking at a transcript and I can visualize myself in that courtroom and pretty much tell what chaos was breaking out when objections weren't preserved or statements were made. So I think that experience gives me a deeper appreciation for the trial record and what's going on in the trial court. My experience on the General District Court gives me tremendous empathy and and a sense of appreciation of the issues that finally wind their way to us and how they're going to impact all of the issues that we will, or the cases, individual cases, that we will never see. The time in the Attorney General's office, tremendous time management skills, time in private practice, sitting at counsel tables, second, third, fourth chair, learning cases from the inside out. And so all of the prior experience, I think, has brought me to this time and place in various and different ways.
Are there things you miss about your life before you took the bench?
I miss the live, in the moment of the trial court. I balance that against the contemplative, being able to think it through of the appellate court. And so there are positives and minuses to both, but I do miss the live in the moment.
Was the sort of contemplative part surprising to you?
No. Okay. I've always, as a trial court judge, I wanted to be able to discuss the case with someone who heard the same case that I heard, as opposed to hearing it through my lens. And so I have that here. And so that aspect of trial court I get here. The live, and the being able to decide it on my own without having to worry about what these other guys and gals think.
You miss a little autonomy.
I do miss a little autonomy.
Justice Millette, you talked a little bit about how your experience before you joined the court has influenced your work, but I was wondering if you could talk a little bit more perhaps about your work in private practice. How is that?
I was with a small firm for 6 years, then I was a sole practitioner actually for 6 years, and then a prosecutor for 4 years. So I basically was in court every day, and in all the courts. I was in district court, I was in circuit court, I was in juvenile courts. So I had a pretty broad understanding of the kind of issues that eventually work their way to circuit court and then eventually work their way to the appellate court.
Has that affected not only how you perform your role now, but your view of the judiciary or what courts should do?
Certainly. I remember specifically some judges that I was just incredibly impressed with and thought those were the kind of people that I would like to emulate if I ever could be a judge myself. Now I got to say I never thought I was going to be a judge, first of all, and certainly not on the Supreme Court when I first started practicing. It was not in my contemplation. It's just something that developed as my law practice and my career went on.
Was that a difficult decision for you to accept the nomination?
Actually, I became a substitute judge pretty early on. I was 30 years old, and when I first started, I said, well, I think I really like this position. I think I can do this fairly well, and I think that it's something I'd like to pursue.
Justice Goodwyn, can you talk a little bit about your prior experience and how that's influenced your work?
Sure. I guess having been a trial lawyer, I was a litigator and a partner in a law firm, as well as a year as a law school professor. More than anything else, I recall as a trial lawyer being very frustrated when judges didn't explain what they were doing. And when I became a judge, one of the things I wanted to make sure was that anybody who left my courtroom understood exactly why I had done what I had done. And I feel like that transparency makes just a big difference in people's perception of fairness. As I write opinions now, the most important thing I want people to understand, or the most important thing to me about the opinion, is that people can understand why I did what I did and why I see things the way I see them. And at that point in time, they can look, and I don't mind them saying, well, that was wrong. And as a trial court judge, I always wanted to explain to people exactly what I'd done, and if they wanted to appeal it, that's how I'm going to get better, right? If it comes up to the Supreme Court and they told me I made a mistake, I know not to do it next time. Whereas I understand some circuit court judges felt like you never explain why you do what you do, because that's how you get reversed. Why would you be afraid of being reversed? I never understood that. Aren't you more concerned about getting it right? And if you can't articulate why you're doing it, I always felt like you shouldn't do it. Mm-hmm. You're not ready to decide the case if you can't explain why you're deciding it. And so I guess that's one of the things I took with me when I came to the bench here.
And was it an easy decision for you?
Which decision?
To take the bench.
Going on the bench? It was something I decided I wanted to do. You know, I practiced law. I was at a firm I loved. I had a great practice. I enjoyed my partners. But I guess I came to the realization that I wasn't very gratified by what I was doing. And I felt like I did not want that to be my life. I wanted to make a contribution in some way to society. And it dawned on me, and a local legislator asked me about being a judge, and honestly, as a young lawyer, I was like, I don't think I'm going out like that, you know? In my mind, it's kind of like, you know, asking Michael Jordan to be an official. I mean, it's like, well, why would I do that? You know, it just didn't register with me that would be something I would be attracted to do.
All balls and strikes.
Exactly, which I didn't want to do. I wanted to be in the game as a younger person, but once you get a family and you have the demands of law practice upon you, and you think about the other things you want to do in the big picture as far as contributing to society, contributing to the community, and it's hard to fit all of that onto your plate. And I realized that by being a judge, I could do public service as my occupation. It doesn't get a whole lot better than that. And once I sat as a substitute judge, I saw I really liked it. I really liked, you know, not trying to figure out how I can, you know, win the case, but what's the right answer? I'm the guy who gets to sit there and make sure everybody is going to be treated fairly. I was like, it doesn't get much better than that.
So what do you find frustrating about the job? Is there something?
I think what I find frustrating about my present job are the time constraints and trying to do a good job. You know, I guess when I was a circuit court judge, and as a circuit court judge, you have to make calls, I mean, on a regular basis all day long. And I felt like the people in the Supreme Court, you know, they sat there and in my mind they kind of like puffed on pipes and, you know, wore tweed jackets with patches on them and, you know, talked about cases and stuff and got around to eventually writing them. And I got here and I found there are a lot of deadlines and a lot of marks we've got to hit as far as like getting our work done. And so it's a very fast pace. And you've got, in a lot of instances, I would say in a given court week, you know, if we have, it used to be 31, 32 cases, now it's more like in the mid-20s. And there are half dozen of those cases that are really, really hard. They're really, really difficult decisions. You're deciding questions that people have written horn books about. You could spend a month working on one of those cases and still not be sure what the answer is, but you got 6 of them. And you got to do them all in 6 weeks. So, you know, that whole time pressure of wanting to do a good job and getting everything done is sometimes frustrating.
Justice Powell? Oh, I'm sorry.
And I was just going to say, because I always feel this way, and in talking to my colleagues, they feel the same way. There's always more you could have done. There's always another case you could have looked at. There's always something else that, you know, you could think about a little bit longer. You think, maybe I could do a little bit better job if I...
One more draft.
Yeah, exactly. But it's like, you know, it's almost like, I keep drawing all these analogies of television shows, but it's kind of like, what is it, the Iron Chef or whatever? It's like, time's up. And, you know, you just have to stop at a certain point, and that's what you have to do with your opinions. At some point, I just got to send it to my colleagues and say, I did the best I could do,
yeah.
and listen to what they have to say.
Justice Powell, so you've joined the court relatively recently in comparison to your colleagues. So what do you find are sort of the frustrations or the things that maybe were new to you?
Could not have said it better, the time constraint. I would like to have the opportunity to write the opinion, send it out, sit around the table with them one more time and discuss every page and every line, put it on the shelf, make sure that it's right before we pull the trigger. And what's frustrating is that we don't have the luxury of all of that time. And I don't know if it would be a better product. Perhaps some of my colleagues have had the benefit of all the time they needed and decided the product that they sent out was the best product. But it's the crush of the time and the amount of the work and the need to keep the train moving and the desire.
The perfect being the enemy of the good, though, otherwise.
And the desire to get it as right as we can get it and the amount of time that we have to devote to it. So it's a little frustrating.
Yeah. So looking back, let me maybe ask several of you to comment on this, to the first day that you took the bench, and maybe Justice Lemons, I'll start with you. What do you wish you'd known then?
Well, I was asked that question shortly after I came on the Supreme Court with a large audience, and someone said, well, what was your biggest surprise when you got there? And I said, well, I thought we were all going to gather together on Fridays at 5 with perhaps a glass of sherry and discuss Marbury versus Madison.
That didn't happen?
It has not happened, and it is not going to happen for all kinds of reasons. You know, my colleagues talk about the workload. It is extraordinary what we have to deal with. There was a time in Virginia, and I remember as a lawyer, where it would take 2.5 to 3 years to get a case through the Supreme Court. And that was not a good time. And the court had a great deal of introspection back then. I wasn't on the court at that time, but I know they did because I've talked with any number of them, and decided that we need to hand down our opinions as best we can during the court week that follows the court week in which it was argued. Now that makes us one of the fastest turnarounds in America. And like Justice Powell, I think that there are cases that simply cannot be decided properly on that schedule. The idea of turning them around quickly is a good idea. There's just some of them that don't fit that model. So I share the view that many of my colleagues have here, that I wish we had more time, and there's some cases that ought to have more time.
Do you feel as if the process should be changed so that you do have more time in some of these cases?
Well, I think actually that's what's happening now. We respect one another on decisions to carry a case over. And we have been carrying cases over more frequently in the last several years than before. I, for one, think that it hasn't done any damage to the institution. To not have done it would have done damage to our relationships and probably damage to the work product. So I'm not at all concerned about the fact that we have been carrying some of these cases over.
Justice MIMS, what do you wish you'd known on the first day you took the bench?
You know, let me rephrase the question slightly. What didn't I know that I quickly learned? And that is the depth of knowledge that each justice has about every case. I had come out of the legislature with 140 members who had to deal with hundreds of issues. And on any issue, most of us had knowledge that was an inch deep. There was always a few legislators who knew more. And ultimately, they have a very fine work product most of the time. Likewise, when I was at the Office of the Attorney General, there were subject matter experts in every single field, and you just had to make sure that you had the right expert working on the right case. Roughly 200 attorneys and handling all of the legal work of the Commonwealth. I got here and found that on every single case, every single justice had a depth of knowledge which at first terrified me and then overwhelmed me, and then gradually I found that I was able to swim in deeper waters, so to speak. But when we publish an opinion, I hope that the litigants and the trial judges and the citizens of the Commonwealth know that it has been as thoroughly vetted and debated and researched and questioned as it's possible to do. And Justice Lemons is right. If we can't do that in a 7-week period, then any one of us can say, let's carry this one over. Let's wait a little bit longer and make sure that we've got it right. And that's quite satisfying, but it's also quite exhausting at times.
I can imagine. Justice Millette, what did you wish you had known?
I think how relentless the pressure of the job is, to be honest with you. I was a circuit court judge for a long time, and I thought I worked very hard. But one of the things about being a circuit court judge is when you complete a week trial or 2-week trial, you have to forget about it when you go home that night, because the next day you may have a domestic relations case. Here, you work on these cases, and then you think about them at night, and you think about them all weekend, and you think about them the next day, and you write your opinion, and you still keep thinking about it. And there really doesn't seem to be a time when you don't feel a pressure of getting the case right. I thought when I took the job, I thought, well, I'm going to have a job where I have a little more control of my time, a little more time management, because heck, they only go to court once every 7 weeks. You know, that's a lot of free time in there, and it has not worked out that way.
And there's not as many people you get to talk about it with either.
Now,
right?
the positive side of all that is, it is absolutely the most amazing experience you can have to put together everything you ever learned as a law student, as a trial lawyer, as a trial judge, as an appellate judge, to put it all together and to try to get the very best product you can get. And it is a real feeling of satisfaction, but it's not without the cost of feeling some pressure on you.
Well, that takes me actually to our last question, and Chief Justice, I'll give you the last word on this. We've just been talking a lot about the pressures of time and the frustration, but as Justice Millette just mentioned, there are a lot of wonderful things about the job as well, and a lot of very fulfilling things. And I was wondering if you could talk a little bit about that aspect of the job.
I think the most fulfilling thing for me has been the incredible people with whom I've had the pleasure of sitting. All of these colleagues and all of those others who are not here now that I've had the opportunity to sit with are just incredibly wonderful, extremely intelligent, caring people. You know, we're friends, but just all that we do for each other and the ways in which we challenge each other each and every day to not only be better people, but to be better jurists. It's just an incredible, court is an incredible place to work. It's been a wonderful opportunity, and it's just an incredible job. Justice Millette is right. It is all-consuming. You're never away from it, but the rewards make up for the cost.
Well, I think that's a perfect note on which to end. So thank you so much to all of you for taking the time to have a conversation with us this afternoon. We really enjoyed it, and thank you very much.